Thank you, Mr. Shima. Will counsel in 126819, State of Kansas versus Arredondo, please.
May it please the court, Peter Meharry for Uraquio, Arredondo. In this case, this comes before this court after my client's conviction for felony murder and an additional charge of child abuse. Those charges arose out of an incident that occurred back in February of 2019. It started with a 911 call my client made seeking medical assistance as the child of his mother was unresponsive. Eventually, the state did charge him with felony murder based upon child abuse, and it's a state theory that he struck his child, causing those injuries and ultimately causing the death. The case went to a bench trial, and we've raised a couple issues on appeal with regard to some of the evidence that district court admitted into evidence and considered in its ruling. Specifically, we've raised issues with regard to evidence obtained during 2 searches of my client's home, and then also evidence obtained through statements of my client that the district court considered in its ruling.
Can we start right at just preservation, or how this gets to us when there's a stipulation that was entered into, joint stipulation at trial that allowed the admissibility of the evidence you're complaining of? How does that come before us?
There was a stipulation, and it is part of the record on appeal. I think it still is properly preserved. The stipulation, particularly the ones with regard to the statements and the evidence from the seizures, came after, at trial, my client did lodge an objection to the testimony regarding the searches of the house. The district court sustained the ruling that it had already made, but then did grant a continuing objection to the defendant with regard to the admission of that evidence. So we believe that the stipulations, and I think this is in the record as well, weren't to waive any arguments. They were just simply to establish foundation, that there was no objection to foundation, and it was an attempt to streamline the admission of the evidence. Particularly with the searches, the evidence from the searches, the motion to suppress was heard the first day of the bench trial. The district court took evidence, considered it, took arguments from both sides, and made a ruling. During trial, the district court noted when that evidence came in, said, I don't need to see the video again. I just saw it during the motion to suppress. One of the officers that testified during the motion to suppress, they just had the district court take notice of it. So I think the clear intent, I think maybe the wording wasn't what we would always want, but the clear intent was to just streamline the admission of the evidence, not to waive any objection that they already had made. And I believe that's the way the district court took it as well, because as I said, it did sustain its ruling in finding the evidence admissible, but did grant a continuing objection to the defense counsel when he asked. So I think it is
in your position today is that the continuing objection went to this other evidence because the notion is that it only related to the officer's testimony.
I think the continuing objection was related to the motion to suppress and all the evidence that was obtained during those searches of my client's home. The way I read the record was that that was the intent and that was the point of the objection, and that's what the district court granted a continuing objection for. So we believe it is properly before this court. And I would also point out that this was a bench trial. And this court in the past has loosened the standards as far as the contemporaneous objection rule this court has when we're dealing with a bench trial.
So let me just, I understand that, but to get back to Justice Biles' clarification, there was you argue a continuing objection to what you call searches, but that then extends to also the statements that were given on different occasions?
I believe the statements is a little different. That is more in line with our argument that because this was a bench trial, because the motion to suppress was actually a state's motion, Jackson v. Deno motion on the statements, That was less than a month before trial. And again, nothing has changed from that point to trial. The same issue, the same arguments. We don't believe an objection is necessary at that point. It's already before the district court. He's already considered it. There's nothing new, and we don't believe that an objection would serve any purpose. The point of the contemporaneous objection is to put it in front of the district court so it can rule on it and make a decision so it does or does not come into trial. This court already did that. And with a bench trial, you don't have that concern. I don't think that this court has noted with jury trials. Frankly, it'd be a waste of time. This was fully litigated. Both these issues were fully litigated before the trial started. The district court made rulings. The evidence didn't change at all. The evidence was the same at trial as it was in these two suppression hearings.
But did the defendant object to the statements during the state's Jackson v. Deno hearing? It seems like that the state moved to admit this evidence. I'm not sure. I don't recall what the position of defendant was. Was there an objection to that admission in response to the state's motion?
Well, the district court had a full evidentiary hearing on it, and then there was arguments from each side as to why these statements should or should not come in. The defense counsel didn't object to the statements coming in during the evidentiary portion because obviously the statements and the surrounding circumstances has to come in for the district court to rule on it. But the defense did argue at the end that these statements should be excluded because defense counsel argued that they were custodial interrogations without the benefit of Miranda. So we believe that's how motions like that work. So the district court had the issue in front of it, ruled on it, and then the trial went forward. So we believe they are properly preserved. And under the circumstances, we believe that evidence should have been ruled inadmissible because the searches, I'll start with the searches. We don't believe that there was a valid consent on the part of my client when the officers went in the second time. There were actually 3 entries. One was in response to the 911 call, which is not contested here on appeal. But then the officers went in a second time, questioned Uraquio, had him kind of do a walkthrough. And then a third time later in the day, different officers did essentially kind of the same thing. But to get in the home, while at the scene, the officers first told Rocky he had to talk to the detective. And then the detective asked, can we go see where? And we don't believe, even though my client went in the house with him, he was...
You're talking about the second or the third?
I'm talking about the second search, right after
that was right after that was on the same day, correct?
All 3 searches were on the same day that we're talking about. The second one occurred just after the child was placed in the ambulance and taken to the hospital. The third one was after my client went to the hospital, was interrogated by the officers, and then they came back.
And that second one was just, and he didn't object to this. Let's go in and explain to me what happened here.
Well, I would argue that if a reasonable person in that situation would have felt obligated to go in and explain it to the officers, given the situation. As I said, the officer said, you've got to talk to the detective. And then the detective, starts asking questions. Uraquio starts explaining. Officer says, can we go see where it happens? Points to the house, starts walking to the house. Rocky follows. That is submission to authority. That's not clear, unequivocal consent. It's not freely given. And a reasonable person in that position would feel an obligation to answer the questions and show the officers where everything took place. Similarly, we believe that's a situation with the third search, which was after my client went to the hospital. Kind of the wrinkle with this one is that the police seized my client's home almost immediately.
Well, it's a crime scene, isn't it?
I would argue they had no probable cause to seize the home at that point. All they had was a 911 call asking for help. Somebody was injured. The child was unresponsive. Nothing more. Police arrived. They gathered up the child, put him in the ambulance, and took him to the hospital. The officers at the scene then secured the house at that point.
So help me with facts here. You said you're not objecting to the entry at the 911 call.
Correct.
Was Did they visibly see there's descriptions of the food having, that made them doubt that there had been, the child had eaten a small piece of the pork chop. Was that visible in that first review?
The first entry, there was body cam, and it basically pans over the apartment as the officer's going in and finding the child. The detail the district court goes into in its ruling, I believe, can only come from the subsequent searches.
Okay.
The initial entry, I mean, the officer was probably in there less than.
So they didn't pick up that little piece of evidence for probable cause basis is where I'm.
No,
Right.
the initial officer that went in, all he did basically was say, where's the child? Went into the bathroom where the child was, gathered the child, and EMS was basically right behind the officer, and they took him out. That officer did nothing as far as investigating the scene. It was only the later searches where the officers went in, talked to Rocky, asked him questions, asked him to kind of do a walkthrough, and that's when they took more detailed pictures, videos, etc. And it's from that evidence, I think, that the district court made it. I mean, the district court went into pretty good detail as to, he noted that the pork chop wasn't even cut. It was just bitten off. And you don't get to that detail from the body cam from the first
What
initial
about the
entry.
broken toilet seat? Is that?
I'm sorry?
visible? The broken toilet seat? Was that apparent?
I think it was there in the initial body cam, but I don't know. I'd have to go back and look to see if you can tell if it's broken. But I don't think you can get the detail that district court relied on, except for the evidence obtained from the second and third searches.
In the third search, let me understand, he consented, signed a written consent.
He signed a written consent, but that was, we believe, coerced, and he was pressured into it because of the circumstances. Namely, they had already seized his house. They told him, you're not getting back in. He raised that concern, and they said, well, we can either do this easy way or the hard way. You can consent or we can get a warrant. At all points, when Rocky raised concern, the police just kept pushing, asking questions, and moving forward. Rocky eventually submitted to their authority. That's what it was. It was not free and voluntary consent.
On the second search, do you think that your client was a suspect at that time? Or is there any evidence in the record to show that he was a suspect? I mean, the second search was like right after the ambulance left, show me where it happened, what happened. I mean, your position is they don't really know anything yet. I mean, you think they thought you're saying it wasn't a crime scene. So was it just investigative at that point?
Your Honor, at that point, they didn't have any indication that I would say points to Rocky as a suspect, or points this as a crime scene, and that bleeds over into why I don't think they could seize the home. But they still went into the home. And they've argued it's consent, and we've argued otherwise. So even though he may not have been a suspect, they still don't just go into his home and say it's investigative. They have to have either a warrant or some exception to the warrant. And we don't believe that they had either of those in this case. They certainly didn't have a warrant, and we don't believe that the consent was valid to allow them to go in. A reasonable person in Rocky's position, given what the officers told him, given what they were doing, would have felt obligated to let him in. But that's not voluntary consent. So even if it was investigative, they still just can't go in willy-nilly and say, we're just going to look around because we're investigating. This is my client's home. He has a right to it. He has a right to privacy in it, and he has a right to keep the officers out. So
Was there any notion that the police would not have been able to get a search warrant?
Yeah, I was gonna ask that.
that was never really raised below. I know the district court, when it was talking about the searches, did note, sometimes he didn't feel the officers were doing anything improper by saying we can go to a judge and try to get a warrant. I don't think the district court weighed in on whether or not it would have given a warrant. It was more, and I don't believe the officers were acting inappropriately, saying they could try to get a warrant. I would argue, as I've argued,
There's no argument of deception or anything like that in this deal.
No, not with the second and third entry. I would argue with regard, and this goes to the statements that my client gave at the police station about a couple months after this. He went in, police asked if they could talk to him. He felt that they were just kind of tying up loose threads. That was the impression he got, but that interview became accusatory pretty quick. And he did feel like he was misled into coming in to talk that day. But as far as the searches and what they talked about at the hospital, I don't believe the district court felt there was any deception or anything like that along those lines.
Can I ask you about prejudice here? The statements, it looks to me like were fairly consistent with the testimony the sister gave as well. So I'm wondering if your argument as to why this evidence was prejudicial is more about identity. Or I don't want to make the argument for you, so you maybe explain to me.
I think this is the statements that came in from my client. They came in through audio and then some of the video when the searches were being done. My client could be heard answering questions. I think those admission of those were a key component in the district court's ruling. The district court made multiple statements that he didn't believe anything my client said. And I don't think you make that credibility determination based upon the secondhand comments of the sister. You make that based upon what you heard directly from my client. And further, I think the statements that my client made were far more expansive. I mean, they were in line with what his sister testified to, but they were more expansive than what she testified to. So I don't think, again, that the district court would have made those credibility determinations that it did without the statements that came directly from my client. For those reasons, we believe the district court did erroneously admit this information, evidence, and consider it in its ruling such that reversal is required. Thank you.
May it please the court, Assistant Solicitor General Ethan Zov Sigler on behalf of the state of Kansas. I think this is a case where I think it's very easy to skip to the end and just ask, is there any chance that the errors they complain about prejudiced the defendant? And the answer is no. I don't believe that there's any question that there is no question that the first entry into the house and the emergency response was valid. I don't really believe that there's much of a question, that there's any question that the second one is valid either. And the third search, which is the only thing where I think there's a legal contention that would have to be resolved, did not get any evidence that was considered by the district court in its ruling. The only evidence discovered during the third search was the replaced toilet seat and the red substances. And of that evidence, the district court explicitly says, for me to speculate on the significance of these suspicious elements on the scene would be futile and certainly inappropriate to take into consideration. So we know that the district court did not consider that evidence in its verdict. So whatever happened with the third search is just harmless because it wasn't considered, and any evidence discovered in the third search was discovered during the second entry into the home and the first entry into the home.
Well, it seems to me that, at least based on the medical evidence, that one might suggest that there is a question as to who the perpetrator of the acts that caused those injuries, the identity, and to that, because the time period of from the medical experts is not narrowed to 1 hour necessarily. It's before up to maybe 24 hours, and that toilet seat and the other evidence arguably is relevant to the identity of who inflicted injuries.
But we know it didn't factor into the district court's judgment because the district court told us explicitly that I don't consider.
I thought the district court kind of suggested or basically said, I don't believe your version. You're lying, basically is what he said. And part of that was based upon the change of clothing and the toilet seat. And that was I think that was from the third search, because the first two were fairly contemporaneous with the call and whatever happened.
I think that it's just not, it doesn't make a difference. The principal question is whether the defendant's statement that the child was choking was true or false, and it is clearly not true. There's no evidence that the child was ever choking. There's no evidence that the story he tells about coming out of the bathroom, seeing the child with his hands on his neck and taking him into the bathroom ever happened. And that's evident from the first video. The kitchen table is completely undisturbed and it is visible in the video. So a fact finder has information that is unquestionably admissible that says he is lying, period. And there's nothing else you ever have to get into to consider whether he is telling the truth. We know from the uncontested evidence, the story he told did not happen, period. And from that point on, everything else is just harmless because his lies are evident from admissible evidence. So getting into the second search, I think this is it is clear that it is consent. If you watch the video, you can see the behavior of Mr. Arredondo. You can see the officers. He's speaking to the officers the entire time. He never breaks conversation. He walks into the house. He's still talking to the officers. He's moving in through the house. He's still talking to the officers. This is fundamentally different from any other case on ambiguous consent where the court continuously points out that the suspect was silent, did not say anything. But I think the reasonable implication of if I am walking into my house and I am speaking, if I am speaking to a person and moving into my house to where they need to follow to hear me, the implication is I'm asking you to come in. And that is a reasonable thing for an officer to believe. So I think that is absolutely consent. Whether he said, yes, please come in, or he's just opening the door for the officers and speaking to them the entire time, it is clear that that is consent. As to the third search, this is where the legal issues, I think, come in. It is clear from the 10th Circuit case, and I'll try to find the citation to that. It is in the brief, that preventing someone from entering their home functions as a seizure. Now, case law in Kansas is ambiguous as to when the seizure occurs. In car stop cases where the defendant is there, the Kansas courts have said that a seizure occurs when a person tries to exert a liberty interest and is denied the ability to exert that interest. But here we have a complicated situation. He's at the hospital. There's no indication that he is trying to go home, trying to exert a liberty interest over his home. It isn't clear that they've actually seized anything at that point. And it's not just at that point what this court has called an attempted seizure. They told him you can't go home, but he has never tried to exert authority over the house. And there are cases, though these involve the seizure of a person, where the court has said until a liberty interest is actually implicated, it is just an attempted seizure and it is not a seizure. The second thing is, there was evidence at that point to give the officers probable cause that a crime had committed. The defendant was alone with an unresponsive child. He had given them a story of what had happened. That story was very evident from the beginning, not true. The things he described did not match the scene in the house. And it was clear at that point that he was lying to the officers. There was an unresponsive child. He was the only one alone with the child. That is probable cause that a crime had been committed. And there are exigent circumstances because if he returns to the house, he can destroy evidence, change evidence. In fact, turns out that he had destroyed and changed the evidence in the house. So the officers could, at that point, reasonably believe that they had probable cause that a crime had been committed in the house, that exigent circumstances existed to keep him from re-entering the house. And at that point, there is no coercion because it's not an unlawful seizure. It is a lawful seizure. and a lawful seizure does not create coercion. And the defendant gave consent while he was in the at the hospital in a room where he was closer to the door than the two officers. They never displayed weapons. They never gave a sign or showing of authority. So his consent is, if the seizure is valid, then his consent is valid. And that is what the law says. As to the statements, I just don't think this issue was preserved. There is no objection at the trial to the statements. The continuing objection is very clearly just to the search. And I think I am not going to stand up here and say that I don't think they have preserved the searches for review. I think that that was subject to an objection. I think they clearly wanted to challenge that. But the statements, that is not true of. They didn't object to the admission of the statements. They never at any point raised that issue. And while the defense cites two cases where an objection isn't required at a bench trial, it's explicit to bench trials on stipulated facts. And the reasoning that this court has given is because typically the reason we require an ongoing or a contemporaneous objection is because facts change. And you can consider testimony at the trial when you are evaluating whether or not the suppression was valid or invalid. The ability to add new facts or further develop facts is why the contemporaneous objection exists. So in a bench trial on stipulated facts, it doesn't make any sense to require another objection at that time because there's no further facts developed. It's stipulated facts, but that's not what happened here. There was additional testimony, additional development, so it required contemporaneous objections to the statements.
As to voluntariness?
Yes, I think even as to the voluntariness.
Well, was there a Jackson v. Deno hearing?
Yes, there was.
Right, okay.
Right.
Okay, about whether the statements could come in,
Yes,
right? And that has to do with whether it was voluntary, right?
yes,
Okay, so what you're saying is that once there's a Jackson v. Deno hearing and the judge determines that the statements were voluntary, that you have to object at trial. You have to make a contemporaneous objection at trial to voluntariness.
I think so. That's always been my understanding. I'm not trying to mislead the court or any.
But what changed though? Because the state moves to admit the statements. And as I understand it, on the very, like, this all happened like contemporaneously. They have that hearing and then they start the trial and they're admitting the statements. I don't understand why this differs.
Well, the hearing was specifically on the searches, and the defense attorney objects.
Okay, so the Jackson v. Deno didn't happen that same day either. I'm sorry.
I believe it happened significantly in advance because at that point they hadn't waived a jury trial yet. It was still set for a jury trial, not a bench trial.
That was my confusion. Thank you.
Yes, and again, in this case, the first officer gets up to testify to what happened in the house, and the defense attorney says, I object based on what we just argued. Could the court just note my continuing objection? And it's specific to the searches. So the defense attorney clearly knew to do this to preserve this issue. And that's why the state isn't challenging preservation of the search question, because I don't think I could do that in good faith. But I do not believe that the statements were the suppression of the statement issue is preserved for review by this court. That was subject to ongoing fact development. There was no objection, no ability to further develop the facts. And so at that point, I think that's not preserved for this court's review on the statements.
On the statements, if we do get to the statements, when you watch the interview, particularly the May 14th interview, it's an interview. It starts off, he comes to the police station, they kind of say what happened here, and it's kind of this give and take about what happened. But midway into it, it does become more accusatory. And I appreciate nothing prevents asking accusatory questions in an interview, but it certainly kind of transitions into an interrogation. Or would you agree with that? And if it does that require any further action on law enforcement to then apprise them that, yeah, you are a suspect and you have the whole Miranda warnings?
I don't believe so. I think you would have to do more in terms of an exertion of force or some sort of element of making a person not believe that they were free to go. I will just say that under the law, there is no distinction between an interview and an interrogation. All police interviews are considered interrogations. So we already account for that. I think even if it's more accusatory, a little bit more standoffish, if you don't have the officers doing something to prevent him from leaving, we have had many cases in which the interviews were hostile, even, in which they were found to be voluntary. So I don't think this case comes close to that line at any of the points where he was interviewed. I also think the police interviews, the interviews at the police station, I also don't think really develop any substantial facts that aren't already present by his statements to his sister, which are admissible, just plainly admissible. So again, we go back to a lot of this just comes down to harmlessness. Evidence was admissible through other means that are not objectionable or not, and were clearly admissible. And those are that is the evidence the court considered, and the result would not have changed if that evidence had been excluded. I do want to touch on one thing that the defense attorney said, and that is the question of the officer saying, hey, Rocky, you need to talk to the officer, or you need to talk to the detective. He does say that. That is true. But I think within the context of what happened in this case, you can look at the fact that the officer is standing substantially far away from the defendant when this happens. He is torn between working on getting the child into the ambulance and trying to talk to the defendant, and there's no show of force. He doesn't try to stop him from leaving. He doesn't reach for a gun. I don't think that statement in and of itself is enough to overcome the voluntariness of the encounter on its own without any other showing of force or attempt to keep him from leaving. So I just wanted to address that one comment. And there's nothing else from the court. Thank you.
Thank you. You reserve 3 minutes.
Thank you. Couple things with regard to, I think this regards preservation. The timeline is the Jackson v. Deno motion was filed January 16, 2021. The hearing was not held until March 28, 2022. The motion to suppress regarding the searches was filed on April 18, 2022, and the hearing on that was on April 20th, 2022, which was the start of the bench trial. So the hearing for this, with regard to the statements, was less than a month before the bench trial, and it was a full evidentiary hearing, as I said before, with both sides making arguments to why the statement should or should not be come in. Given that time frame, again, I don't believe that an objection at trial would have done anything other than Mr. Court saying, yeah, what I said earlier. There's really no point to it. It was the same judge. He had heard all the evidence and made a ruling, and they moved forward.
What's your argument that this was a custodial interrogation?
My argument is that
You look at the factors. Go ahead, explain to me what the strength of your argument is.
with regard to the statements, I'll start with the statements Rocky made at the scene right after the ambulance left. As opposing counsel just referred to, police officer told Rocky he had to talk to the detective. And when you're ordered by a police officer, the standard is what a reasonable person would feel they could do, not what a lawyer or a judge.
Some context here? I mean, this is right at the scene. You need to talk to the officer. It was in response to even Rocky wondering what's going on.
When the officer says you need to talk to the officer, that's an order. And a reasonable person, regardless of what they were thinking, would think also they have to do that. They can't go.
Can,
And if your child was just taken away in an ambulance, you're facing multiple officers. I don't think it's reasonable for us to assume a person would say, okay, he's told me to go talk to the officer. I'm just going to turn around and walk the other way.
let me tell you,
No reasonable person would believe that.
okay, if my recollection of the video is a detective pulls up, gets out of the vehicle, officers working on the child at the ambulance, detective asks the officer what's going on. And that's when the officer's like focused on the child and says to the defendant, talk to the officer. Is that, am
there
I
was-
misreading?
No, that's the video. I mean, the video is what the video is.
Right.
But I would also point out Rocky was in his house and he came back out after he was told he had to talk to the officer. And that is not voluntary consent. That is submission to authority. He was given an order and he followed it.
Doesn't that make virtually every encounter with law enforcement custodial?
It makes certainly a lot of them because
Is that the
again,
case law?
I mean, this court has things it considers, it has all these factors, but it boils down to what a reasonable person would feel like they could do.
Yeah, and you're just saying no reasonable person would ever feel like they can avoid talking to police when police say, I want to talk.
I'm not going that broad, but when you look at the circumstances here, you have an officer telling him to talk to another officer. There are multiple officers around. He can't just go and follow the ambulance because he's told to go talk to the officer.
Well, sure he can, right?
No, he can't. You think a reasonable person would not feel they could do that? I mean, eventually he did. And I know one of the factors is whether or not the person was eventually free to leave. But in each instance, he was free to leave after the police were done with him. After they said, okay, you've answered our questions, go to the hospital. But when you're facing multiple officers directed to talk to them, I don't believe a reasonable person would feel they could ignore that. And that's why they're custodial. And that's why Miranda was warranted, as we've argued. One other point I would like to make, the state said there's no evidence to support what my client said, that the child was choking. My client tried both the Heimlich and CPR to no effect. There was evidence of that. Nurse Randolph noted that there was vomit around his mouth. That's record volume 7, page 229. The EMT Fort saw chunks on the child's face. That's record 12, page 116, 117. And then Nurse McNown noticed white and red liquid in his airway when he was at the hospital. That's record 821. So there is evidence that supports what my client was saying to the officers as far as the child choking and that he was unresponsive as a result. For those reasons, we would again ask this court to reverse this matter for trial. Thank you.
Thank you. Thank you to both counsel for your arguments. The court will take this matter under advisement.